Tonight we're learning more about an Iron Range family whose teenager is being given medical treatment as a emancipated minor, but according to the family, without legal emancipation.
Waverly Monroe is in St. Paul live, where the complicated and controversial situation was discussed today at a news conference. And Waverly, we understand the child's family is very concerned right now.
They are. The child is being given treatment for transitioning genders. Now, the child's lawyer says that the state considers this type of treatment a non-emergency medical treatment. Now, the attorney says that the state allows children to be able to get this type of treatment without officially being emancipated from his or her parents.
I love him unconditionally, and I mean that unconditionally.
Anmarie Calgaro is a concerned mother. When her son was 15, he decided to transition into a female. According to Calgaro, that decision to transition genders is not what concerns her. She says St. Louis County and other agencies have disregarded her parental rights and started treating her now 17-year-old child as emancipated without her consent.
If he changes his mind in the future, and not that he will, and that's not what this is even about.
The suit claims that Park Nicollet Minneapolis Gender Services and Fairview provided the child with what the state calls non-emergency medical treatment for transgender services. Calgaro's lawyer, Eric Cardall, claims the school district and St. Louis County Public Health and Human Services have usurped Calgaro's parental rights.
Anmarie doesn't have any right to notice and to be heard in court.
Minnesota Child Protection League President Michelle Lentz is in full support of Calgaro's taking her complaint to court. She says treating the child as an adult without a court order is a serious violation.
They are financing and prescribing dangerous hormonal drugs and prescription narcotics to a minor without his mother's knowledge, involvement, or consent.
Calgaro is concerned her child is moving too fast.
Nobody, even at 20 years old, would go back and make the same decisions as they would at 16. No, I mean, I can't imagine any of you in this room would go back and go, yeah, I was proud of that moment in my life.
Calgaro claims in her lawsuit that she's not been given the right to refuse this unofficial emancipation.
So what we need is a federal court decision saying that Anmarie's federal due process rights have been violated because her parental rights are a fundamental rights protected under the U.S. Constitution, and she's entitled to a hearing.
Cardall says the situation interferes with Minnesota's strong family legal traditions and expressed concern after speaking to a medical professional that this happens regularly.
I care so deeply for my son. I want to be involved in this process.
The suit is being filed electronically and will most likely be heard in the St. Louis County District Court in Duluth.
And Waverly, you said the school board is involved in this. How exactly are they involved?
Well, the school board for Independent District 2142 has been treating the teenager as an adult, according to Calgaro. She says that she's even been denied all access to her child's information through the school. Now, Cardall says that the board classified the child as an adult, providing exclusive information and decision-making only for the child.
Waverly Monroe reporting live in St. Paul. Thank you, Waverly.